Welcome back. Bill C-51, the Anti-Terrorism Act, was enacted last year despite strong criticism from legal experts. The current Liberal government has promised to amend the law to address those concerns. What do we need to know about the contents of Bill C-51? How does this law impact the average Canadian? Joining me is Azeezah Kanji, lawyer and writer. Welcome to the show, Azeezah.
Thank you for having me.
So what is Bill C-51? I mean, we've heard a lot about it. What is it actually?
Bill C-51 is the Anti-Terrorism Act 2015, and it was a piece of legislation that continues this trend that we've had post 9/11 of imposing increasingly oppressive measures in the name of preventing or fighting terrorism in Canada. It was proposed and pushed through by the Harper government shortly before the election, but we have to remember that Justin Trudeau's Liberals also supported Bill C-51, although they did promise to reform it. This was part of their election platform, and so right now we're in the stages of seeing what the promised comprehensive reform of national security law will look like in Canada under the Liberals.
So why should the average Canadian citizen care about something like Bill C-51? And the reason I'm asking this is because, you know, we've heard of a lot of bills, a lot of new governments that come in, they promise things, but it doesn't really, like, to what extent will Bill C-51 impact my life or, you know, a viewer's life?
So Bill C-51 was pushed through because of the supposed threat that Islamist terrorism or radical Muslims are posing in Canada. As Stephen Harper said during the election, the threat we're facing isn't CSIS, it's ISIS. And so the idea that these measures aren't harmful, on the contrary, they're necessary to protect us from a very salient danger that we're facing, is a very dominant part of the narrative around why these types of measures are necessary. Fear is used in order to make Canadians feel like they need to acquiesce to very fundamental erosions of basic rights and liberties that we're promised in the Charter of Rights and Freedoms. But when we look at how these types of laws have actually been used in the past, we know, for example, that information sharing powers between government agencies, as well as between Canadian government agencies and foreign government agencies like those of the US, very irresponsible information sharing practices were responsible for the torture that was experienced by Canadian citizens like Maher Arar, Abdullah Al-Malki, Ahmed Al-Mati, and Muayyad Nuruddin.
And these are average Canadian citizens that, you know, had no history of anything.
Yes, or the reasons why they were considered suspicious were based on very racist reasoning. So, for example, one of the reasons why Ahmed Al-Mati was considered suspicious was because he had a map of Ottawa in his truck that was discovered when he was crossing the border. But he was a truck driver, and so a map was a very reasonable thing for him to possess. Another reason why he was considered suspicious was because he had drawn up a will before embarking on Hajj, and this was interpreted by security agencies as a sign that he wanted to become a martyr, and this information was shared with the Syrian security agents who tortured him. He was tortured on the basis of this information that was shared with them, and that was only considered suspicious because of an Islamophobic logic. So we know that there have been very deep problems with the way that information sharing has been conducted between government agencies in a way which has exposed Canadians to very serious abuse. Torture is one of the most serious forms of abuse that is condemned in international law, and yet Bill C-51 increases powers of information sharing between government agencies without actually implementing any of the safeguards against abuse that not one but two public inquiries recommended after analysis of the Arar, Al-Mati, Al-Malki, and Nuruddin cases. And so this is why, as people living in Canada, we should be extremely concerned about C-51. We've seen that the practice of CSIS can also be a threat to the very basic rights of Canadians.
So recently in the media, we've also seen ISIS come out, just focusing a little bit on them. They've come out and, called Canadian imams who are on their hit list, quote unquote, right? So one of the things I think that came under Bill C-51 or that's being explored right now is the establishment of the Office of Counter-radicalization. So I understand, the concerns that you're bringing up and how it would impact the average citizen like me and you, and, we've seen that. So how do we, taking all of this into context, how does this factor in? Like, wouldn't an office actually be helpful? Because then you have, CSIS, and obviously I would assume that people would work with them, but then you're also addressing this ISIS threat, which people are feeling is very real. So are there elements of Bill C-51 that you think are actually good for the community, or no?
So the Office of Counter-radicalization isn't proposed in Bill C-51. It's part of the recent Liberal budget that was unveiled, which dedicates $35 million to the establishment of an Office of Counter-radicalization.
But it would support things under Bill C-51, right? Or help address some of those?
Well, Bill C-51 and counter-radicalization are both manifestations of the way that counterterrorism is increasingly being seen as a preventive exercise.
Okay.
So the goal of the state now isn't just to punish people for what they have done, but to prevent them from doing things in the first place. So, for example, Bill C-51 creates a new speech crime of advocating or promoting terrorism offenses in general, which is a very vague category, but we can see that the point of that is to treat as criminal things which previously would have just been considered pre-criminal signs that someone might become a quote-unquote terrorist. That is, speaking words or writing signs that appear to be supporting terrorism, but that aren't actually connected to any actual act of violence. The Office of Counter-radicalization is another manifestation, as I said, of the increasingly preventive focus of counterterrorism, where the goal is to look at things which make us think that someone is likely to engage in violence in the future, and then prevent them before they do that. And this is often seen as a softer way of addressing terrorism than using criminal law or very harsh police powers. It's seen as a less violent and coercive way, something that's represented often as working with communities in order to stop problems before they happen. But if we look at the way that counter-radicalization or countering violent extremism programs have actually unrolled in other countries that Canada has consulted as being experts or guides for counter-radicalization programs, particularly in the UK and the US, we see that the effects of these programs have actually been very far from the promises of them. So in the US, for example, countering violent extremism programs have focused almost exclusively on the Muslim population, and even exercises which were represented as police simply engaging with the community in order to build better relationships with them, even those have been exploited by state agents in order to collect and collate information on the Muslim community. And the underlying problem with these counter-radicalization and countering violent extremism programs is that they're based on a fundamentally problematic concept of radicalization, that people possessing certain radical beliefs is what makes them predisposed to engage in violent extremism, which is actually not based on any kind of rigorous science. Yeah. In fact, the scientific basis for it, even though it's claimed to be very solid, is actually extremely spurious. And part of the problem is that in developing these markers for radicalization, they've really only looked at the Muslim population. And so in the FBI and NYPD's models of radicalization, for example, they've ended up focusing on things like men growing beards or people wearing traditional clothing as signs that people will engage in violent extremism. But it's completely fallacious. It's because they're only looking at the Muslim population as a source of danger in the first place. And so then all of their markers for what makes someone potentially dangerous are also things that are connected with the Muslim community.
So what about specific components of Bill C-51? Are they also kind of similar to what you're talking about, or is it a little bit different?
Mm-hmm. So we've mentioned a couple of different components with Bill C-51 so far. The increased information sharing that government agencies are now allowed to engage in about a very broad range of facets of Canadians' lives, including information that the Canadian Border Services Agency would have, or financial information. All of that can be shared between government agents about people who they think are engaging in activities that quote unquote undermine the security of Canada.
Without any knowledge of the person that information is being shared.
Or without, so the person about whom the information is being shared doesn't know that the information is being shared about them. And what makes someone vulnerable to having information being shared about them is engagement in a very broad range of activities. So activities that make someone vulnerable to this are, for example, interference with critical infrastructure in Canada, which could mean participation in a protest that involves a roadblock, or activities that undermine the security of another state. And I think the most important example of this is engagement in BDS campaigns, which we know has really been demonized as an activity which is undermining the state of Israel. You know, when they say that, of course, they're not talking about arms sales to Saudi, which are being used to bomb Yemen. You know, that's not an activity which is considered to undermine the security of another state. They're really talking about the security of particular states. Another effect of Bill C-51 is expansion of police's powers to preventively arrest and detain people. Previously in the criminal code, the police could preventively arrest people if they were certainly going to commit a terrorism offense and the arrest was necessary to prevent this. Now they're allowed to arrest people if they may commit a terrorism offense and the arrest might prevent it, which is a very low standard for arresting people. Lawyers Clayton Ruby and Nader Hassan, according to them, now Muslims could be arrested if, you know, they're standing in a group outside a mosque, maybe speaking in Arabic or in Urdu, and you know, who knows what they're talking about. But if it seems to a police officer from the outside that they may engage in terrorism, this preventive arrest power would be available to them. And so that's definitely something that we should be concerned about. Now, there's no evidence yet that the police have used this power, but we do know that they are relying increasingly on peace bonds, which is another feature of Bill C-51. Bill C-51 makes it easier for peace bonds to be imposed on people who might engage in terrorism. And what peace bonds are a mechanism which allows a judge to place extremely restrictive conditions on people without any criminal charge or trial.
So these are all continuing to be based on the ideas of they may, that kind of
Exactly.
idea.
So they're all preventive, like the same logic of counter-radicalization. And so with peace bonds, for example, we've seen people who have written things which are inflammatory on the internet, having conditions like bans from internet use, bans from cell phone use, geographical restrictions, passport confiscations, those kinds of conditions imposed on people who haven't done anything warranting a criminal charge or trial, and yet their lives can be very restrictive and imposed upon simply on the strength of a peace bond. Similar conditions have been available to people held under security certificates, which were only available for non-citizens and were a way for the state to impose conditions on people who they thought might be a security threat. And we've seen the extremely disruptive and devastating impact of those kinds of conditions on people's lives and on people's families, so that one man who was subject to a security certificate, for example, said that he would rather go back to jail rather than live outside of jail, but under the cloud and under the constraint of these very restrictive conditions. And so when we look at Bill C-51 and what it's actually doing, and when we see the types of very restrictive measures that can be imposed on people, preventive arrest, detention for up to 7 days, conditions under peace bonds, we see that it really is something that we should be worried about, because it's the state getting into the business of not punishing people for what they have done, but looking into people's heads and what they've written and who they know, and trying to prevent them from committing crimes in the first place, but in a way that is extremely restrictive to their freedom.
So what should the average citizen do in light of, you know, you've shared a lot of information, obviously it is scary. What should we as Canadian citizens be doing to engage elected officials on this?
First of all, I think it's very important that we know what's actually in the bill so we can engage on the substance of it and not just make claims about how Bill C-51 is bad or it's repressive, but we can actually ground those kinds of arguments in the substance of what Bill C-51 is doing. A very interesting finding from the Environics survey, which we discussed in another episode, is that while a majority of Muslim Canadians are opposed to Bill C-51, they at the same time think that CSIS and RCMP have an appropriate amount of power, which is actually a contradiction because most of what Bill C-51 does is increase the powers of CSIS and RCMP. And so I think that this signals that while the Muslim community is aware that Bill C-51 is oppressive and bad law, they don't know enough about what's in the law in order to also be able to condemn the increased powers that it has given to CSIS and RCMP. So I think the first and most important step is for us to be educated about what is actually in the bill so we can engage on the substance. And then the next step is to engage our elected officials, but also engage more broadly in the public sphere. There have been protests against Bill C-51, and I think as the Muslim community, who has been the primary target of national security law and policy in this country, and who has served as the justification for increased powers for security agencies, because we're always represented as the security threat who the rest of the nation needs saving from, I think that we should also be participating in these broader public and social movements against laws like Bill C-51.
This was very informative. Thank you so much, Azeezah.
Thank you very much.
Hey YouTube, we hope you benefited from this video. If you liked it, or if you didn't, let us know in the comments below. And if you're interested in learning more, check out some of our other videos. And don't forget to subscribe so you can get new videos every Monday, Wednesday, and Friday.